Hey, my name is Hannah Hill. I'm the Research and Policy Director for the National Foundation for Gun Rights. And today we filed an emergency appeal with the Supreme Court, and we're asking them to step in and provide relief to the people of Illinois by suspending the assault weapons ban passed by their state and passed also by the city of Naperville. So first off, a little bit of background. Last year, the Supreme Court ruled in New York State Rifle and Pistol Association versus Bruen that lower courts actually have to apply and uphold the Second Amendment. That's an overly simplistic version, but that's essentially what the ruling meant for the lower courts. So shortly after that, we filed 7 lawsuits challenging assault weapons bans and standard capacity magazine bans all across the United States. And we've been succeeding, at least in some of our cases. But before I get into that, real quick, would you take a minute to like this video and subscribe to our channel? That will allow you to stay up to date, not only with Second Amendment litigation news, but with gun rights news in general. So, initially, right after Bruen, we were able to get a temporary restraining order blocking a local assault weapons ban in the state of Colorado. That was the first post-Bruen win for gun rights litigation. And that was followed shortly thereafter by a second temporary restraining order, and that ended up with our getting a stay of enforcement for 4 local assault weapons bans in the state of Colorado. So all 4 of those are stayed throughout the remainder of that lawsuit. But we have not been that fortunate everywhere. Recently, our case in the state of Illinois saw one of the worst gun rights rulings that our legal team has ever seen. And that's saying something because there are a lot of really bad rulings out there. So, a little background on that case. So it started when the city of Naperville decided to ban the sale of AR-15s. This, again, is shortly after Bruen. They had no excuse for doing this. And the local gun store owner, Robert Beavis, who owns Law Weapons and Supply there in Naperville, was mobilizing against this proposed ordinance. The citizens showed up en masse at the city council meeting to protest the passage of that ordinance, but unfortunately the city council thumbed their noses at their constituents and passed it anyway. So we teamed up with Robert. We were filing lawsuits elsewhere, so we just added Naperville to the list. We filed a lawsuit to block that ordinance, and we asked for a temporary restraining order there as well to keep Robert in business so he could continue to sell guns there in Naperville. When the state of Illinois passed a statewide assault weapons ban shortly thereafter, we just expanded our lawsuit to include that as well. Unfortunately, the district court refused to grant both a temporary restraining order and a preliminary injunction. The judge in this case refused to follow the Supreme Court's precedent in Heller, which says that essentially the Second Amendment does protect the right to own commonly used weapons for self-defense. Now, normally in a case like this, the judge will invent all kinds of legal and logical acrobatics to weasel their way around what the Supreme Court has said and explain why it doesn't actually apply in this case. The judge didn't do that here. She just ignored it. And she invented her own test out of thin air that says essentially that a government can ban particularly dangerous weapons if it wants to do that. Now, that's not what the Supreme Court said, and that's not what the Second Amendment said either. But that is what this judge ruled. And then she went on to violate the Bruen test, which says that a government to ban or to regulate the Second Amendment has to prove that its regulation is consistent with the text, history, and tradition of the Second Amendment. So instead of doing that, she reverted back to the old means end test. So essentially what she did is a cost-benefit analysis on the Second Amendment. Is it really worth insisting upon in this case? Do we think that it's too dangerous to have Second Amendment rights in this case? She can't do that, not under the Supreme Court's precedent in Bruen, but that's what she did essentially. So we appealed that to the 7th Circuit. And recently, the 7th Circuit simply, without explaining their rationale for it, they simply declined to step in on an emergency level. They declined to give us an immediate suspension of these laws, although they're still considering our motion for preliminary injunction, which would suspend the laws for the rest of the case. However, if typical cases are anything to go by, we don't expect a ruling on the preliminary injunction side of this until later on this summer. So meanwhile, Robert's business, Law Weapons and Supply, is taking financial hit after financial hit. And if he doesn't obtain relief soon, he will be facing a loss of his business, simply because his local government and the state government decided, we don't like your business, even though it is constitutionally protected, even though what you are selling is protected under the Second Amendment. We don't like it. We're going to outlaw it because we don't like the business, we don't like your product, and we don't like the customers who buy them. It's one of the most unconstitutional things ever, and we're asking the Supreme Court to put a stop to that. So since the Seventh Circuit declined to step in and give us essentially a temporary restraining order, we're asking the Supreme Court to give us one. Because, again, Robert's about to go out of business, and the people of Illinois deserve to exercise their Second Amendment rights. A right delayed is a right denied, and that's essentially what we are saying to the Supreme Court in this filing. Now, the technical term for this is emergency application for injunction pending appellate review. That essentially means we want the Supreme Court to step in now, suspend both the Naperville Ordinance and the state assault weapons ban, while the Seventh Circuit is considering whether to give us a preliminary injunction. This is considered a long shot. Typically speaking, the Supreme Court does not give emergency relief like this. The Supreme Court prefers to step in only after the district court process and the appellate court process are finished. But these are extenuating circumstances, and this is an open-shut case. The Supreme Court precedents, if they are applied, make for a very short ruling. No, you cannot ban assault weapons. No, you cannot ban the sale of AR-15s. Yes, you must apply Bruen. You must honor the intent, the text, history, and tradition of the Second Amendment. It's not rocket science. It's not fancy. And it doesn't have to be a complicated or a convoluted ruling. This is an open shut case, and we're simply asking the Supreme Court to enforce its own precedent. So that's what we've asked the Supreme Court for today, and we will keep you posted on what they say. Now, if you would like to help us continue to fight these assault weapons bans at all levels of the federal courts all across the United States, there's a link in the comments below where you can contribute to our legal war chest. And don't forget to like and subscribe to our channel so as to stay up to date with the latest Second Amendment news and to be the first to know when the Supreme Court actually does rule on our motion. Thank you very much.